we are back. Get Legit LLC. And today, from our desk, we will be looking at Justice Clarence Thomas. For those of you who have not yet subscribed, please do so. Subscribe. We're growing. We're a growing channel. Subscribe to our channel. If you like our content, please comment, like, and do share. This video is for educational purposes. And today we will be discussing Justice Clarence Thomas. Those of you might be asking, who is Justice Clarence Thomas? For those of you who do not already know, well, Justice Clarence Thomas is the most senior associate judge today. He was nominated by President George Bush to succeed the first Black U.S. Supreme Court judge, Thurgood Marshall, in 1991. And he has been serving as a United States Supreme Court judge ever since. Thurgood Marshall, for those of you who do not know who Thurgood Marshall is, he was born January 2nd, 1908. He passed away January 24th, 1993. He was born July 2nd, 1908 and passed away January 24th, 1993. He was an American civil rights lawyer and jurist who served as an associate justice of the Supreme Court of the United States from 1967 until 1991. He was Supreme Court's first African-American jurist. Remember, I said previous that Justice Thomas was the judge who succeeded Justice Thurgood Marshall. So some of you might be asking whether or not Justice Clarence Thomas is a controversial figure. And then some of you might very well say, well, he's a judge. Duh. The more important question, though, to my mind, given the recent debacle that he's dealing with, having regard to the ProPublica report, is what does he stand for? So let's get into it. Let's take a walk down memory lane and look at some of his controversial position as it relates to certain things having to do with our constitutional rights. In an article updated May 11, 2020, entitled Justice Clarence Thomas Has Found His Moment, it states, most importantly for the law in America, Thomas's view of the Constitution would lead to reversal of abortion rights. Well, we do know now that such has happened. Remember, this article was written, updated 2020. The elimination of gun regulations and this diminishment of press rights. Last year, he also expressed doubt about the constitutional underpinnings of a 1963 landmark guaranteeing that criminal defendants too poor to hire their own lawyer are appointed counsel. He has also pushed his colleagues to take up more cases on which lower courts are divided and chastise the majority for avoiding tough issues. In late 2018, Thomas wrote that the majority had rejected a petition because it involved Planned Parenthood and, open quotes, a politically fraught issue. The case arose from Republican-led state efforts to deny Medicaid money for Planned Parenthood services to poor patients. When the court spurned an appeal by Louisiana officials, Thomas, joined by Gorsuch and Samuel Alito, dissented. Open quotes. Some tenuous connection to a publicly fraught issue does not justify abdicating our judicial duty, close quotes. Thomas wrote, if anything, open quotes, if anything, mutually applying the law is all the more important when political issues are in the background. We are responsible for the confusion among the lower courts, and it is our job to fix it. Bear in mind, this article was updated 2020, and today we're in 2023. So I'll go back to a New York Times article. It was an opinionated article as it relates to Justice Thomas's brand of judicial logic. It was written by Lincoln Kaplan, October 22nd, 2011. So the opinion piece states some of Justice Thomas's radical views, and so we share what the opinion article states. So it says, Justice Thomas is basically, they're making reference to him. They say he favors cutting back the authority of the federal government and letting states decide for themselves how to safeguard the health and welfare of their citizens. He believes that the Constitution left religion up to the states, and that the First Amendment's prohibition against Congress's enacting laws on the establishment of religion was intended to protect the rights of states to do as they please. He wants to roll back what most Americans consider racial progress because, open quotes, the Constitution abhors classifications based on race. And even when the government uses them to solve problems and confers benefits, it demeans us all. Extreme as those views are, the most extreme part of Justice Thomas's record is not what he decides, but how. Justice Antonia Scalia told a biographer of Justice Thomas, Ken Foskett, that Justice Thomas doesn't believe in stare decisis, period. Even to conservatives like Justice Scalia, and originalists claiming to interpret the Constitution as the framers understood it, stare decisis, or following legal precedents, is integral to Supreme Court law. In guiding the court, that principle favors gradual, over-sweeping change. It is indispensable in assuring court rulings that, the article continues, that since Justice Thomas has been on the bench, his opposing view about precedent has seeped into the broader political debate. Others on the court have also become more willing to override or twist the meaning of precedent in critical areas. In 2007, for example, the court decided in a 5-4 vote that public school systems could no longer take account of a student's race in trying to achieve integration. The court's conservative majority turned the meaning of Brown v. Board of Education upside down in barring communities from voluntarily fulfilling Brown's promise to end segregation. In 2010, in the Citizens United case, the court's conservatives swept aside decades of established precedents in ruling that government may not restrict corporate and union. This year, in a 5-4 vote, in the AT&T Mobility Concepcion, the conservatives upheld the arbitration clause in a customer contract, requiring the signer to waive the right to take part in a class action suit. In a show of rank activism, the court went far beyond the question it was asked to decide when it suggested that all businesses can shut down class actions by relying on arbitration clauses in consumer contracts. In each of these cases, Justice Thomas voted with the majority, but filed separate opinions because, as he wrote in the Citizens United case, the majority's constitutional analysis does not go far enough. In that case, he said, the court should have struck down all donor disclosure requirements in campaign laws. His idiosyncratic approach has made him a solo dissenter almost twice as often as any other justice of the court. Last term, he dissented when the court struck down on First Amendment grounds a California statute that banned the sale of violent video games to children. He concluded that the court was wrong because the framers, open quotes, could not possibly have understood the freedom of speech to include an unqualified right to speak to minors, yet cited no legal evidence from the nation's founding. The scholar Lee Epstein and Andrew Martin found in a recent study that Justice Thomas, while a steadfast conservative vote, has rarely been the swing vote in a majority case. But that does not mean he has no impact. He has spent 20 years advancing a judicial philosophy that rejects restraints in decision-making and fidelity to legal precedent. His disregard for essential principles has surely added to public cynicism about how Supreme Court law is made. Clarence Thomas' beneficial friendship with a GOP mega donor. So now, we are going to touch on the issue as to why is it that Justice Thomas is in the news today, having nothing to do with any of his controversial views and decisions, but rather his friendship. So ProPublica has, in an article, states, a decade-long relationship between Supreme Court Justice Clarence Thomas and Texas real estate billionaire Harlan Crow, including an undisclosed real estate deal and lavish international travel, has raised questions about influence and ethics at the nation's highest court. And the nation's highest court they're talking about here, guys, is the United States Supreme Court. So there are several articles that ProPublica has written, such as one entitled Clarence Thomas and the Billionaire, another billionaire Harlan Crow bought property from Clarence Thomas. The justice didn't disclose the deal, to an article entitled Clarence Thomas Defends Undisclosed Family Trips with GOP Mega Donor. Okay, so let's now get into it. But before we do so, did I forget to ask, could you please subscribe to my channel if you like my content? Could you please comment so we can all have a lively discussion on this most important topic? And please do like and share. Before we get into the report, though, it's newsworthy and it's much important that we first discuss who is ProPublica. Well, ProPublica is an independent nonprofit newsroom that produces investigative journalism with moral force. They dig deep into important issues, shining a light on abuses of power and betrayals of public trust. And they stick with those issues as long as it keeps to hold power to account. And so now ProPublica has put forward a report on Justice Clarence Thomas, which has led to several discussions. So we have on April 6th at 8 p.m., there was an article written by the three authors of the report, Justin Elliott, Joshua Kaplan, and Alex Majerski. And the first article was Lawmakers Call for Investigation and Ethics Reform in Response to ProPublica Report on Justice Thomas. Then there's another report, Clarence Thomas and the Billionaire. So you all need to look at those articles. There's an article, Clarence Thomas Defends Undisclosed Family Trips with GOP Mega Donor, and Congress members announce hearing, demand Chief Justice investigate Clarence Thomas's trip. So let's look at one of the articles written by ProPublica. This one is entitled, Billionaire Harlan Crow Bought Property from Clarence Thomas. The justice didn't disclose the deal. So it's saying, in 2014, one of Texas billionaire Harlan Crow's companies purchased a string of properties on a quiet residential street in Savannah, Georgia. It wasn't a marquee acquisition for the real estate magnate, just an old single-story home and 2 vacant lots down the road. What made it noteworthy were the people on the other side of the deal. Supreme Court Justice Clarence Thomas and his relatives. The transaction marks the first known instance of money flowing from the Republican mega donor to the Supreme Court Justice. The Crow Company bought the properties for $133,363 from 3 co-owners: Thomas, his mother, and the family of Thomas's late brother, according to a state tax document and a deed dated October 15, 2014, filed at the Chatham County Courthouse. The purchase put Crow in an unusual position. He now owned the house where the justice's elderly mother was living. Soon after the sale was completed, contractors began work on tens of thousands of dollars of improvement on the 2-bedroom, 1-bathroom home, which looks out onto a patch of orange trees. The renovations included a carport, a repaired roof, and a new fence and gate, accordingly to city permit records and blueprints. Clarence Thomas defends the undisclosed family trips with GOP mega donor. So, Justice Thomas, when the report was released, he defended it, and he said, open quotes, "Early in my tenure at the court, I sought guidance from my colleagues and others in the judiciary and was advised that this sort of personal hospitality from close personal friends who did not have business before the court was not reportable." Thomas said in the statement, "I have endeavored to follow that counsel throughout my tenure and have always sought to comply with the disclosure guidelines." Close quotes. But 7 legal ethics experts consulted by ProPublica, including former ethics lawyers for Congress and the White House, said the law clearly requires that gifts of transportation, including private jet flights, be disclosed. If Thomas is arguing otherwise, the expert said, he is incorrect. So, ProPublica's story Thursday revealed that Thomas had taken international cruises on Crow's super yacht, flown on Crow's private jet, and regularly vacationed at Crow's private resort in the private resorts. In one instance, Thomas flew on Crow's jet from Washington Dulles Airport to New Haven, Connecticut, then flew back 3 hours later. Thomas did not respond to detailed questions for this story. His statement Friday did not dispute ProPublica's reporting about his trips. It also did not address broader criticisms from ethics experts and other judges that by repeatedly accepting such trips, he broke long-standing ethical norms for judges' conduct. In a previous statement to ProPublica, Crow said that Thomas, open quotes, never asked for any of this hospitality, close quotes, and that his treatment of the justice was, open quotes, no different from the hospitality we have extended to many other dear friends, close quotes. Let's get into Harlan Crow's statement. And this is his statement. I'm going to read verbatim from his statement. It says, "As the name indicates, Savannah Historic Developments, LLC was established to preserve a historic area in Savannah, Georgia, which includes the childhood home of Justice Thomas. Similarly, the property that was previously the Oyster Cannery was acquired, and we created the Pinpoint Heritage Museum located in the community where Justice Thomas was born in support of Georgia's coastal heritage and the Gullah community. I continue to financially support the operation of the Pinpoint Heritage Museum. These philanthropic investments are a part of my broader commitment to historical preservation and American education." It continues. My intention is to one day create a public museum at the Thomas home dedicated to telling the story of our nation's second Black Supreme Court Justice, who was born in Pinpoint, Georgia, and later raised in Savannah. I approached the Thomas family about my desire to maintain this historic site so future generations would learn about the inspiring life of one of our greatest Americans who was born into abject poverty in segregation and moved to this home to live with his grandparents when he was 7. In this home, Clarence Thomas learned the importance of hard work and preservation and how he was created equal in the image of God despite the racist laws and customs that he lived under. This home provided the foundation for Justice Thomas to overcome these immense challenges and to eventually serve his country on the Supreme Court. Justice Thomas's story represents the best of America. The historic Thomas property and the surrounding properties were purchased at market rate because on many factors, including the size, quality, and livability of the dwellings. The surrounding properties had fallen into disrepair and needed to be demolished for health and safety reasons. Improvements were also made to the Thomas property to preserve its long-term viability and accessibility to the public. Savannah Historic Developments, LLC, built one new house and made it available to a local police officer. The other lots were later sold to a vetted builder who was committed to improving the quality of the neighborhood and preserving its historical integrity. So guys, that is Harlan Crow's statement in relation to the report as it relates to the sale of the property that was not disclosed by Justice Thomas, and you make what you want of it. But that is his statement, that is his rationale. So, continuing from the report from ProPublica, they're saying that a law was passed in the wake of the Watergate scandal, the Ethics in Government Act, and it requires Supreme Court justices and many other federal officials to report most gifts to the public. Justices are generally required to report all gifts worth more than $415, defined as anything of value that they don't repay the full cost of. Gifts are disclosed in an annual financial report that is made public. There are exceptions, and experts parsing the legality of Thomas's failure to disclose the travel have been focused on a carve-out known to the personal hospitality exemption. The exemption states that gifts of food, lodging, or entertainment received as personal hospitality don't have to be disclosed. The law defines personal hospitality in a way that further limits the exception. It only applies to gifts received from an individual at that person's home or at properties that they or their family own. For those of you who would like to see the document, there is a document. It can be found online, and you can look at the document on the second page where it says notes. Under notes, it tells you what is exempted. So one of the things it says here, it says, the personal hospitality gift reporting exemption applies only to food, lodging, or entertainment, and is intended to cover such gifts of a personal, non-business nature. Therefore, the reporting exemption does not include, and I'm going to read what it does not include. It does not include, 1, gifts other than food, lodging, or entertainment, such as transportation that substitutes for commercial transportation. Private jet rides. Gifts extended for a business purpose. Gifts extended at property or facilities owned by an entity rather than by an individual or an individual's family, even if the entity is owned wholly or in part by an individual or an individual's family. gifts paid for by any individual or entity other than the individual providing the hospitality, or for which the individual providing the hospitality receives reimbursement or a tax deduction related to furnishing the hospitality, or gifts extended at a commercial property, example, a resort or restaurant, or at a property that is regularly rented out to others for a business purpose. You guys, you can go online and you can find the actual document. If you go into the actual report from ProPublica, it is the link attached, so you can click where you see food, lodging, and entertainment. You click on that and it takes you directly to the original document. So please do go to those documents, read it, and read for yourself and make your own interpretation that you make from it. So I'm going to go through, in the article, ProPublica said that they spoke to several experts. And so I'm going to read snippets that were in the report from different experts. So I'm going to read what those experts are saying, at least 4 of them. One said, I don't think you can make an argument that private jet flights need not be included under the statute. That was Stephen Gillers. He's a professor emeritus and ethics expert at New York University Law School. Another expert said, it is absolutely impossible that anyone could reasonably interpret that exception to apply to private jet flights. This is Walter Schraub, former director of the U.S. Office of Government Ethics. Then we go on to a third one. He said, Richard Painter, who served as the chief ethics lawyer for George W. Bush, White House, said Thomas's explanation as to why he didn't disclose the trips makes absolutely no sense. Painter emphasized that the exemption only covers 3 categories: food, lodging, and entertainment. Private jet flights would fall into none of those, he said. And the 4th expert said, Justice Thomas likes to focus on the language of authoritative texts, and that's not what he's doing in this statement. And that's Kathleen Clark. She's a legal ethics expert at the Washington University in St. Louis. You all can go online, find the document, read it for yourself, and make what you may of it. So continuing on in the ProPublica's article, it says, in the Ethics in Government Act, Congress explicitly stated that the law covers Supreme Court justices, but Chief Justice John Roberts has raised questions about Congress' power to impose rules on the Supreme Court. Open quotes. This is Justice Roberts, Chief Justice Roberts says, the court has never addressed whether Congress may impose those requirements on the Supreme Court, Roberts wrote. He wrote this roughly a decade ago in an annual report on the judiciary entitled The Justices Nevertheless Comply with Those Provisions. Here is that report. Now let's look to see what the report is saying. I'll get into the report so you all could understand and have an idea of what is happening. So I'll start from the 2nd page. No, I'll start from the 3rd page. The 3rd page goes into, the 3rd page gets into the Code of Conduct of United States Judges, okay? Let me see if I have that here. Okay, let's get into the report. The Code of Conduct of United States Judges, it says, what is now known as the Judicial Conference of the United States was created by Congress in 1922 to provide national guidance to the lower federal courts. The Chief Justice chairs the Judicial Conference, which includes the Chief Justice of each of the 13 federal judicial circuits and a district judge from each circuit. Judicial Conference conducts much of its work through 25 committees, including the Committee on Codes of Conduct. As noted, that committee has promulgated and periodically revises the Code of Conduct for the United States judges. It also provides advice on the formal and informal basis to a judge and judicial employees on the meaning and application of the code's provision. The Code of Conduct, by its express terms, applies only to lower federal court judges. That reflects a fundamental difference between the Supreme Court and the other federal courts. Article 3 of the Constitution creates only one court, and that one court is the Supreme Court of the United States. But it empowers Congress to establish additional lower federal courts that the framers knew the country would need. Congress instituted the Judicial Conference for the benefit of the courts it had created. Because the Judicial Conference is an instrument for the management of the lower federal courts, its committees have no mandate to prescribe rules or standards for any other body. Some observers suggested that because the Judicial Conference Code conduct applies only to lower federal courts, the Supreme Court is exempt from the ethical principles that lower courts observe. That observation rests on misconceptions about both the Supreme Court and the Code. It goes on to say, all members of the court do in fact consult the Code in assessing their ethical obligations. In this way, the Code plays the same role for the justices as it does for other federal judges, since, as the commentary accompanying Canon 1 of the Code explains, the Code, quote, open quotes, is designed to provide guidance to judges, close quotes. It serves the same purpose as the 1924 canons that Chief Justice Taft helped to develop, and justices today use the Code for precisely that purpose. Each does so for the same compelling, practical reasons. Every justice seeks to follow high ethical standards, and the Judicial Conference's Code of Conduct provides a current and uniform source of guidance designed with specific reference to the needs and obligations of the federal judiciary. The Code of Conduct is not, of course, the only source of guidance for justices or lower court judges. Because it is phrased in general terms, it cannot answer all questions. And because the Code was developed for the benefit of lower federal courts, it does not adequately answer some of the ethical considerations unique to the Supreme Court. The justices, like other federal judges, may consult a wide variety of other authorities to resolve specific ethical issues. They may turn to judicial opinions, treatises, scholarly articles, and disciplinary decisions. They may also seek advice from the court's legal office, from Judicial Conference's Committee on Codes of Conduct, and from colleagues. For that reason, the court has had no reason to adopt the Code of Conduct as its definitive source of ethical guidance. But as a practical matter, the Code remains a starting point and a key source of guidance that the justices, as well as their lower court colleagues, for the justices as well as the lower court colleagues. Note Justice Thomas's explanation is that he sought guidance from his colleagues. And here, Chief Justice Roberts is saying that one of the source While the code is a starting point, they can make reference to other sources for guidance, and one such source being colleagues. Then it's for you to look at and see whether or not you believe Justice Thomas was outside when it comes to his ethical obligations. This document can be found, you can look, can be found on the website. If you go into ProPublica's article where you see Thomas Roberts wrote, it's in blue, you can click on that link and you click on it, it takes you directly to this document. And this document is what is made reference to when he's speaking of this 2011 year-end report on federal judiciary. So this discussion was had as way back as 2011, as far back as 2011. So one of the things here, when it talks about talks about financial disclosure and gifts regulation, I'll just read a bit from this so you could have an appreciation. And this can be found on page 6. It says, in addition to establishing the Judicial Conference, Congress has enacted legislation addressing a number of specific ethical matters. In particular, Congress had directed justices and judges to comply with both financial reporting requirements and limitations on the receipt of gifts and outside earned income. The court has never addressed whether Congress may impose those requirements on the Supreme Court. The justices nevertheless comply with those provisions. The justices file the same financial disclosure reports as other federal judges. Those reports disclose, among other things, the justices' non-governmental income, investments, liabilities, gifts, and reimbursements from third parties. For purposes of sound administration, the justices, like lower court judges, file those reports through the Judicial Conference's Committee on Financial Disclosure. That committee provides guidance on the sometimes complex reporting requirement. So here, Justice Roberts is speaking as it relates to the requirement for disclosure, financial disclosure. So guys, you can find that report, look at it, and make what you may of it. So now, let's get into this thing. Is this the first time questions about Justice Thomas Clarence disclosure has come up? Is this the first time? Well, according to ProPublica's article, questions about Thomas's compliance with the disclosure law have come up in the past. In 2011, he announced that he was amending years' worth of his disclosure forms because he had failed to disclose the sources of his wife, Ginny's income. So the answer is yes. No, it's not the first time. Questions have come up as it relates to his disclosure. For those of you who are interested, you can look at the law as it relates to the filing of reports. It can be found at US Code 104.5a, and it states exactly what is the requirement for filing and as it relates to Justice Thomas's issue. So, if Justice Clarence Thomas is forced to resign, he will be the second justice of the Supreme Court to resign. Well, naturally, you might be asking, well, who is the first? Is there a first? Well, of course, there is a first, if he's going to be the second. The first is Supreme Court Judge, former Judge, Abe Fortas, who resigned May 15th, 1968. Just a quick reminder for those of you who haven't yet subscribed, please subscribe. Please subscribe. Anyway, let's get into Justice Abe Fortas. In an article entitled The Cautionary Tale of Abe Fortas, written by Ciara Torres Pilsey, dated February 6, 2018, she states, open quotes, Abe Fortas's political star was really on the rise. He was appointed to be an associate judge of the Supreme Court by President Lyndon Johnson in 1965. And then luck seemed to shine on him again when Chief Justice Warren decided to retire in 1968. President Johnson then nominated Associate Justice Fortas to become Chief Justice Fortas, which required Senate approval. And that's when everything went pear-shaped. Justice Fortas was known for his close friendships with LBJ, but it wasn't until his confirmation hearings to be elevated to Chief Justice did the closeness of the relationship become fully examined in a public forum. As the U.S. Senate still notes, the second Fortas nomination hearing revealed, open quotes, as a sitting judge, he regularly attended White House staff meetings. He briefed the president on secret court deliberations and, on behalf of the president, he pressured senators who opposed the war in Vietnam. Abe Fortas' political star was really on the rise. He was, I think I read this already. Okay. And if all of that wasn't bad enough, the hearings also revealed that his former law partner, Paul Porter, the Porter of Arnold and Porter, set up a gig for Fortas to teach summer school at American University. That probably wouldn't have been all that controversial, except Fortas' salary wasn't paid by American University. Rather, former Arnold and Porter clients, many of whom had cases potentially heading to the Supreme Court, paid the summer school salary for Fortas. The payment was $15,000, which doesn't sound like much today, but was 40% of the salary he earned as a Supreme Court justice. Conservative senators with Strom Thurmond leading the charge filibustered Fortas' elevation until he was forced to withdraw his name. Fortas remained on the Supreme Court for another year when another financial scandal sunk his career. He took $20,000 from the Wolfson Foundation, which was a family foundation of Louis Wolfson, who was indicted for securities fraud. Justice Fortas returned the money, but his reputation was ruined and he stepped down from the court in shame. His cautionary tale should teach all justices that the appearance of impropriety can crush an otherwise stellar career. The Abe Fortas problem isn't new. Justice Clarence Thomas has repeatedly been chastised over the years for his taking money from conservative groups for various speaking engagements. So there you have it. While this issue is at the front of discussion, it is for you all to educate yourselves, read the articles, come to your conclusion, and join in the conversation. It has to do with a justice of the highest court in this land. And so it is important. It is an important topic, and it is very important that you all take part in this so that you know what is happening and that you can then make a decision and have a say in what is happening and put forward your opinion if that is the case. So for now, that is it. That is our report. That is our update as relates to Justice Clarence Thomas. And I end again by asking you all to please continue supporting the channel. And for those of you who haven't yet subscribed, please subscribe to the channel. Hit that subscribe button, hit that like button, comment, do comment, so we could continue this lively discussion. And please go on ProPublica's page and read all the materials that they have there, okay? Thank you for your support. And with that, Get Legit LLC brings this broadcast to an end.